The Justice of the Appellate Division, 4th Department. Hear thee, hear thee, hear thee. All persons having business before this court will draw near, give their attendance, and they shall be heard.
Good morning, please be seated. The first case for oral argument this morning is 461, People versus Nicole Lacey.
Good morning, Your Honors. Ken Tyler for Miss Lacey. Glad I said Miss Lacey this time. I tend to rely on our brief unless the panel has any questions. Just a comment or two about our point one. We contend that it was error for the court to sua sponte dismiss a selected juror. There's some ambiguity whether the juror was sworn or unsworn. In our brief, we spent some time on that. I would acknowledge, I'm not sure that makes a difference under 270-15 sub 4.
You think they're the same?
Under 270-15 sub 4, the court can, a party can lodge a cause-based challenge based upon information that wasn't known before a juror was sworn. I acknowledge that. That might not make a difference to the analysis. Our point is really that the court conducted no inquiry. There's no real record basis for having excused the juror without at least giving defense counsel what he asked for, which was a chance for a further inquiry, and I just wanted to make that point a little clearer.
Didn't defense counsel actually thank the judge for getting rid of the juror?
He thanked the judge after the judge twice told him, you know, he had asked twice, I'd like to conduct a further inquiry to delve into this, and then he said thank you. It's certainly courtroom decorum. I don't know that that's a failure to preserve on the attorney's part. Thank you.
Thank you.
Good morning, Your Honors. Morgan Mayer on behalf of Christina Mills for the people of the state of New York. I would also like to just touch upon point one very briefly. We maintain our position that the issue was unpreserved because no actual objection into the dismissal was launched. Defense counsel on reply brief argued otherwise, but although an inquiry was made, there was no objection actually launched, and based on that, we submit that the argument is unpreserved.
Do you think they're the same thing, being selected versus being sworn? Different rights attached to each of them or not? It's interesting. I mean, you mentioned in your briefs that it's a novel issue, and it's playing around in my head a little bit, you know, so.
I battle with that a little bit myself, to be honest with you. I think the argument can be made the same, whether or not he was sworn. He was dismissed, and we just maintain our argument that it was unpreserved.
And we don't even know if everything in the record indicates that he wasn't sworn before he was dismissed anyway, so.
There was, at no point did the court formally swear in any jurors, yes.
Okay,
And if there are no further questions, I'll rest on my papers.
thank you.
Thank you.
People versus Sinkler.
Good morning, Your Honors. Cleo Weiss on behalf of Deshaun Sinkler. In this case, the people argued that I'm asking this court to overturn Court of Appeals precedent, but I think that frames the issue incorrectly. I'm asking this court to follow the United States Supreme Court's precedent, and to the extent that the Chestnut decision conflicts with the Supreme Court's precedent, this court must follow the Supreme Court's binding decisions. So I ask this court to disregard the Chestnut decision only to the extent that it conflicts with and is sort of trumped by Supreme Court precedent. And the issue at play in this case are exceptions to the Fourth Amendment's warrant requirement. And where Chestnut conflicts with United States versus D. Ray has to do with the extent of the automobile exception for warrants. And D. Ray held with perfect clarity that when law enforcement have probable cause to search a vehicle and they don't need a warrant under that warrant exception, that does not justify a warrantless search of the bodies of any passengers in that car. So we have no exception to the warrant requirement for the search of passengers' bodies. And in 1999 in Wyoming versus Houghton, the Supreme Court doubles down on that and says again very clearly, Houghton says you can search the purses and the physical belongings of passengers, but you may not search the passengers' bodies. And Mr. Sinkler is not the first to note this inconsistency between Fourth Amendment jurisprudence and the Chestnut line of decisions. A district court judge for the Western District of New York has said, with greatest respect for the New York State courts, finds that the Chestnut line of decisions is incompatible with federal constitutional law. So this is really a split between New York courts seem to be implicitly creating a new exception to the warrant requirement where the Supreme Court has specifically and explicitly said there is no exception. If there are no questions about that conflict between the case law, I would just turn to briefly say that other theories of exceptions to the warrant requirement, such as search incident to arrest, were not argued by the people below. They've relied exclusively on the Chestnut line of cases. Supreme Court's decision in this case was predicated exclusively on the Chestnut line of cases. So there is no other ground for this court to review the suppression decision.
I don't dispute your analysis in terms of the contradiction we have between the Chestnut line of cases and the federal cases. But in this particular case, what strikes me is that we would have a situation where if both of the occupants of the vehicle had been arrested for the marijuana possession, as the law existed at that time, and if both were told to return to the back of the police vehicle, as the driver was, what we would have is we'd have two people in the back of a police vehicle, one of whom was armed. And that would be the situation that we would have had here. Should we be concerned with that possible result?
Your Honor, you shouldn't be concerned with that result for two reasons. One, I think that there was, though of course the people never argued this, they did not chart their course of litigation in this way, there is no probable cause for Mr. Sinkler's arrest. And that's because when you have contraband in a car, in this case there's a blunt, the driver points out, yeah, I have a blunt here in the cup holder, you have to have, probable cause has to be specified to an individual. That's, I think, Ibarra versus Illinois. So just because there's contraband in the car, that does not provide probable cause for the search of all occupants without some sort of indicia or objective facts that indicate, in this case, that Mr. Sinkler was connected with possessing that de minimis amount of marijuana. So I don't think we can assume that they could have had probable cause, and again, that wasn't argued below. And if Mr. Sinkler was properly arrested, if we're in a hypothetical situation, there was more drugs, or let's say the marijuana was on the passenger side, so there were some facts connecting it to Mr. Sinkler. In such a circumstance, the police would have probable cause to arrest Mr. Sinkler, and upon arresting him, they could have patted him down before putting him in the back of the car. So I don't think that overruling the Chestnut line of cases, or not overruling exactly, but steering more in the direction of United States versus D. Ray and what the Supreme Court has told us would never put police at risk, because any time when they're going to take a suspect into custody and arrest them, they can, of course, frisk them for weapons.
Thank you.
If there's no further questions, I'll just touch briefly on the sentencing issue. And just to note that the people have no objection to the remedy of this court imposing the sentence of 2.5 years of post-release supervision, and I would ask this court to do so as a matter of judicial economy. Thank you.
Good morning, Amy Wallensack on behalf of the people. I plan to rely primarily on my brief, only to touch on this court has repeatedly held that a trained officer's detection of the odor of marijuana emanating from a vehicle provides him with probable cause to search both the vehicle and the passengers. And this court, in its decision in People v. Boswell, recently rejected a very similar argument being advanced by defendant, and we would ask the court to do that again, unless there are any questions.
467, People versus Edmonds. Sorry, just waiting. Good morning. Can you unmute yourself, please? Thank you. Go ahead.
Honors. May it please the court, Bagya good day for Appellant Quentin Edmonds. Today I will be focusing on point 1 of my brief. Mr. Edmonds' plea was involuntary, as his statements at sentencing negated his intent for his guilty plea and raised a possible intoxication defense. And the court failed to ensure that Mr. Edmonds understood the nature of his charge and that he was knowingly waiving his right to raise a possible defense in his case. Although Mr. Edmonds did not move to withdraw his plea, his statements at sentencing, which significantly cast doubt on the voluntariness of his plea, did trigger the narrow exception to the preservation requirement set forth in People v. Lopez.
That does not apply to bringing these things up at sentencing. That applies to bringing these things up during the plea.
Lost her.
Oh, we lost her.
Just her video cut out.
Oh, can you still hear me?
Hello?
Hello?
We can't see you, but we can hear you.
Yeah. Yeah.
There you are.
Okay.
Did you hear? We lost you again.
I don't know why the video keeps cutting off.
Okay, why don't we do it orally then, okay?
Okay. Yes, Your Honor, this court has declined to extend the Lopez exception to post-plea statements. However, we assert that Mr. Edmonds' claim is reviewable under the Lopez rule, as his case is distinct from its predecessors, in that applying the Lopez exception would not jeopardize the purpose of the preservation requirement in his case. In fact, it would ensure due process in his plea proceedings. And our rationale is based on the decision under People v. Beasley, in that based on which we state that his post-plea statement showed his lack of understanding of his guilty plea and his lack of awareness that he was waiving a potential defense in his case, which did impose a duty upon the court to conduct further inquiry to ensure that he had knowingly and voluntarily entered his guilty plea.
We'll look at that very carefully. Thank you.
Thank you, Your Honor. And just moving to the merits of his case, his statements at sentencing expressly negated his specific intent for murder in the second degree. In fact, in this case, it's significant because the trial court acknowledged the denial of his intent and even acknowledged the intoxication defense in his case. Yet at no point did the court ask Mr. Edmonds whether he understood that the intent required for his guilty plea, or whether he understood the possible defense in his case. It is significant that the court instead conducted an independent conclusion on his statements. It concluded that intent was clear and intoxication defense in this case lacked merit.
Okay, we'll look at that very carefully. I think we understand that.
John, if there are no further questions, I will rest on that.
Thank you very much.
Good morning. May it please the court, Will Zickel for the people. Defense counsel and I agree on a good deal about point one of the defendant's brief. First, there was nothing in the plea elocution itself which would trigger further inquiry by the court. It's not argued in the brief, and it's not apparent in the record in any way. And second, there was no motion to withdraw. So I submit that the Lopez exception was not triggered, and that the entire issue is not preserved by that lack of motion to withdraw the plea. And this court has been very, very clear that in the absence of such a motion, there is no obligation on the part of the trial court or sentencing court to conduct any further inquiry at the time of sentencing with respect to statements that were made at a sentencing proceeding, which would arguably even raise some question about the voluntariness of the plea. There is no obligation on the part of the court. That has been the law in the 4th Department for many, many years, as set by this court. It was most recently reaffirmed in People versus Lacey, which is 225-83-1276, which is a case that was handed down after we submitted our briefs. But this court has been very consistent in that regard, and I request that the court remain so.
Can I ask you about point 2 real quick?
Oh, certainly.
Sure. In your brief, you mentioned that you agree that the waiver of appeal was improper because it failed to accurately advise the defendants of the appeal rights he would retain. In reading the oral colloquy, the judge mentioned 6 rights that you'd retain, 5 of which were restated again in the written waiver. What more were you looking for?
There was the colloquy that was used at the time was not the colloquy that was contained in the standard or model colloquies.
I believe it was.
I thought perhaps it wasn't.
I believe this, as a matter of fact, I believe this happened, that had been true of this particular judge's colloquies, and he changed it. And during the waiver of appeal, they even asked, so is this a new form? And he asked the parties, is this a new form? And they acknowledged that it was, so.
Well, my apologies to Judge Zambito in that regard. And as the court points out, it had been incorrectly put for some time.
Right, and so he changed it up.
And we're not bound by your concession, which may have been faulty.
I certainly won't argue that point, Your Honor.
Thank you.
Thank you.
470, People versus Warnell. I guess so. I guess I said Warnell, but it's Warnley. Well, say it again.
Warnley.
Okay.
I'm assuming that's.
Yeah, okay, great. Thank you. Go ahead, Mr. Schifrin.
Good morning. May it please the court. Brian Schifrin on behalf of Mr. Wormley. We urge first in point 1 that it is not reasonable for Officer Barbera to believe that Mr. Wormley had consented to the opening of the cubby doors that were latched underneath the rear porch. That search exceeded the consent search, which that officer had either heard or had been communicated to him by another officer. He testified that he had not spoken to Mr. Wormley prior to opening the doors. He testified that the officer who was doing that was Captain Desane. Testified he had not spoken to Captain Desane prior to opening the doors. And most importantly, he testified in response to a question from the prosecutor that he had not heard any request for permission to open those doors.
But wasn't there testimony that he told the police that they could see anything they needed? Isn't that the quote, anything they needed?
What he testified was we could check the page 447 of the record, we could check the basement. He claimed that Werner said we could check the basement, we could search inside if we wanted to, and anything we needed. It's important to recognize that two things. That was not what actually talking to Wormley testified that Wormley said. Wormley said, according to Captain Desane, is that, do you want to look in the basement? And then Wormley and Desane started walking to the front driveway away from the porch. More importantly, that language at the end, and anything we needed, was not even purportedly a quote, but rather that was a summary of the impression that Barbera had that Mr. Wormley was being cooperative, but he was. With respect to the very specific requests that to search limited areas of the premises, he always said yes. That's was never a general request nor a general consent. Point out, at page 26 of the DA's brief, the respondent urges this court to ignore the testimony elicited by the prosecutor that he had not heard a request for permission to search underneath the porch, and to find otherwise, to find that he actually did hear that. There's nothing in the record to support this court ignoring the answer elicited from their witness, from their prosecutor, with no follow-up questions, and substitute other testimony. To conduct a warrantless search, an officer either has to have personal knowledge justifying the warrantless search, or such knowledge has to be communicated by another officer who has such
We'll look
knowledge.
at that very carefully, Mr. Schifrin.
One final thing on that point before I move on to point two is, in this case where that knowledge wasn't there, the people argue this issue wasn't preserved. We argue two things. One, we argue it was preserved because in response to the motion and post-hearing memorandum seeking suppression on the grounds of lack of consent, the court ruled otherwise. Therefore, we urge it was preserved under 47005 subdivision 2. It wasn't. In this case, where the clear strategy was to seek suppression of this evidence, the DA, trial counsel argued extensively to seek suppression of this evidence. Any failure to do so, because if the claim wasn't raised in the correct manner, was not strategy. That was a prejudicial mistake, which therefore was ineffective assistance of counsel in this case because of the critical nature of this evidence.
But, and Counselor, you're not advocating or saying that there was any testimony that the defendant limited the scope of the search. You're just saying that he didn't explicitly authorize it under the porch.
Absolutely. There's no burden for a defendant. There's not a presumption that you can search anywhere unless I limit it. The at trial, and in response to your question, Your Honor, is that at trial, the district attorney pointed out repeatedly that he didn't say you can't search a particular spot. He was never asked in a general request, can we search everywhere? And he said, no, we can only search these areas. There was a series of specific requests. Can we search your garage? Can we search? Yes. Can you search a garbage totes? Yes. And there was never an opportunity to say no because he was agreeing to all these specific requests. To find a general consent when none was requested because the defendant didn't say you can't search other areas, it would be switch the burdens on its head. Police cannot search without a warrant unless there is consent, and there wasn't consent proved by this officer.
Okay, I think we have that argument.
With respect to point two, it's our position that the court improperly precluded the defense from introducing evidence as to how the jailhouse informant, Jason Siplin, could have obtained the information he claimed to have heard from Mr. Wormley. The strongest and most direct proof Mr. Wormley was the person who committed the murder was the incentivized testimony of Mr. Siplin, who said 20 years on the sentence by his testimony. He testified that while he and Mr. Wormley were in jail, Mr. Wormley had provided a detailed account to him as to how and why he committed this murder. Furthermore, Siplin testified that he had not heard any other accounts from any other sources as to this murder. Therefore, sending a message, anything I'm telling you, people in the jury, have to come directly from Mr. Wormley. Given the importance of this recorded confession and given this testimony, it had first to know the source about the highly publicized murder case. The defense attorney understandably sought in numerous ways to show how easily it would have been for Mr. Siplin to have learned this information. Yet every attempt to do so was resulted in sustained objections from the court, from the prosecutor objected, and the court sustained. There was a jail deputy, Deputy Mayo, who was asked, could inmates have seen the computers deputies had with internet access? Objection sustained. Did inmates have direct internet access? Objection sustained.
We understand all that, Mr. Schifrin.
Well, it's important in understanding it. The court kept out a newspaper article from the Democratic Chronicle about the case, ruling that articles in the newspaper are not self-authenticating, despite the fact CPOL 4532 not only says that they're self-authenticating, that's the heading of that section. Then the court said, well, newspapers are not obliged to be accurate. Mr. Wormley wasn't seeking to introduce the article because he's arguing for the truth of the content thereof, but to show that the content of the purported jailhouse admissions were available to him, both from the newspaper and through the internet available to inmates. The court ruled that this was all speculation and the prejudicial impact outweighed the probative value.
Okay, we'll look
But
at that.
Counsel, does that make a difference? Based on all the other evidence, wouldn't that still be a harmless error?
Well, a few things about that. I mean, I want to respond to that, but let's just finish that before I was in the middle of because in terms of speculation, I think it's important to know the people are always able to bring in evidence that the defendant had the opportunity to commit a crime. Indeed, and the same way, it was not only relevant but critical to show that this informant had the opportunity to learn this information elsewhere. Last December, in People versus Surter, cited in my brief in People versus page 50, the Court of Appeals reversed a conviction because the trial court excluded evidence of alternative explanations, holding was too speculative. The Court of Appeals held that goes to weight, not admissibility. It was a reversible error to not allow the jury to get this. In this case, the jury not hearing, there was other ways that Mr. Siplin, the many other ways that Mr. Siplin could have learned the information contained in that statement, and only hearing that he got it directly from Mr. Wormley, of course, had to credit it. And even worse, after he kept out the newspaper article by objecting, having the objection sustained, the prosecutor in summation argued, well, newspapers wouldn't contain all the details in the purported admission. We don't know that, and the jury didn't know that because they didn't see the actual article. So
Again, I think we understand all that.
with respect to Justice Alton's question, first of all, there could be no stronger evidence in this case than a purported confession. That was the strongest evidence by far. And to say that the admission of a purported confession is harmless, I think is wrong in a case where there wasn't an admission.
I think we have that argument.
And finally, we think the other evidence in the case should be expressed too, because as I argued in point 1, it was the fruits of an unlawful search. Unless there are other questions, I'll rest in my brief. Thank you, Your Honor.
Thank you.
Morning, Your Honors. Todd Cassell on behalf of the people. I'll keep this brief. I submit that the defendant did consent to the search under the porch, both specifically to Captain Desane and both generally, and that he, according to the testimony of Officer LaBarbera is how it's pronounced, said that the police could do anything they needed. He had given consent to search the garage, the driveway area, which included the porch, inside the house, inside his basement. He did not delimit his consent in any respect, and in fact was overly cooperative and helpful according to the testimony of the officers. And counsel continues to indicate that the cubby was latched. There's no testimony to the fact that the cubby was latched. That's kind of immaterial, but he continues to refer to it as latched. It was not. Both by the defendant's words and conduct, he consented to this search of the area. I submit that the trial court was correct in denying the application to suppress. And even if this court were to find that the search was impermissible, the correct recourse would be to remit the matter for decision on the emergency doctrine, which the people put in their brief. As to point 2, I disagree that the testimony of the informant or the jail informant was the strongest proof. The strongest proof was the physical proof. The blood on the jacket that the defendant was seen wearing the day of the murder that matched Ted Boucher. That was the strongest proof in this case, as well as the defendant hosing off the area where Ted Boucher's hearing aid was found, 20 some odd feet from where his body was recovered, in addition to the other hearing aid found in the big trash. Defense counsel at trial did not ask Mr. Siplin if he had read any news articles concerning the publication of this case. And therefore, the people objected to the introduction of this evidence at trial. That did not stop defense counsel at the trial from eliciting information about the publication of this case through other witnesses and from summing up on it quite extensively at the close of his case, at the close of the case. People submit the court was correct in its decision to sustain the people's objection, and then in any event, it was harmless error as the weight of evidence was quite overwhelming in this case. If there are no questions, I would rest on my papers.
Just in regard to the last point, I mean, the other possible source of the information, aside from the tablet, aside from the televisions, all of which the jury was able to hear, was the use of the deputy's computer. Is that right, or the deputy station computer?
That was where defense counsel was trying to go, was that, again, was to suggest or imply that Mr. Siplin could have access beyond that which other inmates would be by accessing the actual corrections officer's computer station to see something in addition. But again, the question was never asked of Jason Siplin, which is really the critical thing. The counsel was essentially trying to impeach the testimony of Jason Siplin on a question he never asked Jason Siplin.
Nor was any witness, either Siplin or one of the corrections officers, asked, does this particular did Siplin in particular have access to this computer?
Which was really the crux of the people's argument at trial, is there's a foundational problem in the attempt to introduce this evidence. And it was really speculative. And that, and not referenced in counsel's brief, is one of the other many bases that the judge sustained the people's objection, not just on the business records or the CPLR, but on the fact that this would be misleading and confusing to the jury.
Thank you.
Thank you.
472, Ross versus Northeast. Cedra.
Good morning, Your Honors. May it please the court, Robert Goodwin on behalf of the defendant, the Hamburg Central School District. Your Honors, we raised a series of points in our brief why we believe the damages trial should be set aside. I'm actually going to jump to the final argument we raised because of this court's familiarity with this case. I believe 3 of Your Honors did decide the appeal from the summary judgment motion. This wasn't a typical damages only trial. Months after the trial was held, this court decided this is not a 240 case. The issue of absolute liability is removed from this case. And I know there's been some equating of it to, well, reverse bifurcation. Again, absolute liability does not make this a negligence case. And if this is a truly reverse bifurcation scenario, you're not hearing statements at a damages only trial. They're 100% responsible. That clouded this entire verdict. And similar to the Griffin case, it kind of lays the framework why courts need to do this together. If there's no absolute liability, everything needs to be retried.
So I have a question. I noticed that your record was a little unusual. It wasn't the whole record of the entire trial. And so in searching to try to see, what objections were raised and how the court handled it, I was not able to determine that. If you could help me there.
Sure. And I will submit, Your Honor, I think on that specific objection, that wasn't there solely because it couldn't be there. On the issue of absolute liability, that was the finding of the court. That was the law of the case.
So it wasn't an untrue statement.
It was not an untrue statement at the time the verdict was made.
So, if I put myself in the shoes of the Supreme Court judge, on something like this, would you have wished that you said something, made some kind of objection, so maybe the judge could have limited the amount of, repetition of that issue? Listen, you don't have to worry about liability, just damages. That's been decided.
Correct. And I think in a little bit, Your Honor, I know beforehand, I believe there was a letter motion to the court that did address somewhat that issue. Because of the framework of the case, though, in a perfect world, yes, but I think, and that's why we're taking the interest of justice approach, because counsel's hands were somewhat tied.
Okay, so you're somewhat conceding that really wasn't brought up before the court, and the court didn't have a chance to say, okay, plaintiff lawyer, don't mention this a bunch of times because I'm going to take care of it when I charge the jury.
Correct, because I think given the framework of that case, there really could not have been the opportunity. And I think, again, going back to Griffin, we see why. It wasn't until the trial was ended that the trial judge says, oh, I made a mistake. We should do everything again. And that was affirmed by the first department. And briefly on the unified trial framework, going back to our first point, I think there's another need for that in this case because of the late disclosures by plaintiff's counsel as it relates to certain medical conditions and medical records. It's not just prejudice, but I think there's also a presumption of prejudice that's built into the court rules. The uniform rules say that medical records containing new information has to be given to defense counsel 30 days, at least 30 days before trial. And then it goes on to say 10 days after that, there has to be an opportunity to examine the plaintiff. That didn't happen in this case. When we learned about the additional surgeries, the stimulators, it was respectively 15, 6, and 5 days before trial. Yeah, and so, Your Honors, because of that, the prejudice prevented us from doing that. Aside from the unified trial, we do raise the arguments that the verdict was excessive. We'll rely on our papers and the cases we cite there, unless the court has any additional questions on those points.
Thank you.
Thank you, Your Honors.
And may it please the court, Sarah Hansen for Northeast Diversification. I'm going to try to not retread on what Mr. Goodwin indicated, but this is a case we believe that from start to finish mandates and calls out for a new trial on damages. I want to concentrate on the cervical neurostimulator and some of the comments that were made in the brief of the plaintiff regarding that. The cervical neurostimulator was not something that was recommended by Dr. Capicato until November 17th. We're talking about a week before trial, less than that if you're going to go from the original trial date. There was a pattern of last minute disclosures, new witnesses, new depositions that were done. The trial was moved by a couple of days to accommodate for that. And then you've got this neurostimulator that comes up November 17th.
Counsel, isn't a neurostimulator something that's, I guess I would say like a treatment of last resort? You try all these other things, and when you don't get relief, that's something it did follow that pattern. Like, I mean, the fact that it's late.
Well, Your Honor, it didn't. So the neurostimulator, the plaintiffs argued that there was some discussion of a cervical surgery in August of 2022. Dr. Capicato was very clear about that at record 125, 126, that the surgery that they're talking about in August of 2022 was the fusion surgery, the 2-level fusion that he had recommended for several years. Notably, on the stand, he gets up and says, no, it's not a 2-level anymore, it's a 4-level. And Judge Hanna did at that point appropriately say, you can't change your testimony now in the stand. That's a new surgery, a 4-level versus a 2-level. And he precluded him from getting into that. Why he did not do that with the neurostimulator, which is a different procedure. The neurostimulator would have involved a trial neurostimulator procedure, and only if that was successful, and that was, according to Capicato, less than 50% of the time historically, then he would have the permanent, and that involved additional surgeries after that. So we believe that this is very similar to the cases Holbrook versus James Away, and this court's decision in Conroe versus Barmore-Sellstrom in 2004, it's a significant change. We're not talking about one more surgery. We're talking about possibly several, the replacement of the batteries and all of that.
Did you ask for an adjournment?
Pardon?
Did you?
We did. We asked multiple times, and that is in the record that we requested an adjournment because of this, because of the new neurostimulator, because he has an MRI on November 21st. And then all of a sudden on November 29th, we're 48 hours before trial and he's having a right shoulder repair. There's a new tear all of a sudden. None of this is because of new treatment. Dr. Capicato says when he comes back in November, he's not supposed to be seen until August of 2023. And when he comes back suddenly in November, it's not because his complaints have increased, they've actually decreased. Dr. Tetro says, Mr. Ross didn't come to me and say, I want to see you before the trial. I talked to Mr. Panapinto, and because of that, I decided to order an MRI, and the MRI is done without our knowledge. We're before the court on November 17th for motions in limine. The MRI is done on the 21st. Tetro has ordered it, and he's seen Capicato. We have no idea about any of this. And all of a sudden, the 29th, new tear, new surgery. We request an adjournment. The adjournment's not granted. We requested it multiple times before jury selection. We requested it before trial. It wasn't done. So again, this is the beginning of the trial. Then you go through the trial itself. You've got the lidocaine treatment that's all of a sudden in there. You've got the separate cervical spinal decompression that's all of a sudden in there. And by a doctor whose practice we didn't even have an authorization for until days before the trial. And then you've got this at the bookend of the trial, you've got the labor law 240 determination, and particularly concerns that I have about some of the statements made. Judge Bannister, you properly noted, it was true that at the time that this trial was undergoing, that there was a strict liability determination. There wasn't anything factually inaccurate about that. We don't believe there was anything we could have objected to because it was the truth. But
if you're telling us now that you feel that the number of times, and you noted that in your brief a few separate times, I think at least 4 times that it was mentioned. And if you thought that that would be prejudicial, even though it was true, what counsel said at the time. But you could have, I think in my mind, I think you could have made an objection to repeated references to that ruling so that you wouldn't be in this situation.
Your Honor, and I would say that it's not, my concern is not necessarily the number of times it was referenced. My concern is that at the end of the trial, Mr. Panapinto said, there was this determination made by Judge Montour, and they didn't admit fault. They didn't take responsibility. They had to be found responsible. And because of that, he used this baseball analogy, a kid with a baseball that broke a window. And, you know, after you break a window, the parents have to tell them, you have to tell the person that you're sorry, and you have to pay for your damages. And he made an analogy to my client as the kid with the baseball.
Okay. Did anybody object to that?
Well, no, Your Honor, not at that time. There were objections to the 240 being referenced during the trial, but not at that exact time. But in doing so, it's my concern is that the plaintiff's counsel essentially joined the issues of damages and liability.
We'll look at that.
Okay, thank you, Your Honor. And I think that again,
let me say this. All right, you have damages and liability, and you're supposed to consider them separately, even if the trial was all in one. You know, the judge wants it to be that the jury concentrates on damages and concentrates on liability, and they do that separately. You know, so I don't know. I guess when counsel says, listen, you don't have to worry about liability, that's already been decided. Isn't he in effect saying, concentrate on damages alone? Like, don't consider the liability.
but that's not what he said. The plaintiff could have taken that position and said, liability is out there. It's 100%. You don't have to talk about that. That's not your decision to make. What he said was, when you issue your damages decision, consider the fact that they've never taken responsibility for that determination. They had to be told by Judge Montour that they were at fault. Judge Montour's decision, gone. Not only was it thrown out, the whole 240 claim was thrown out. So it's our position that having linked the two, when one goes, the other one has to go as well. And again, I think you look at the case from the start to the finish, from the pretrial surprises to the things that came through trial, to the fact that this is a $3.86 million verdict for a person who had a single arthroscopic surgery.
We understand all
Yeah,
that, and we're gonna.
and practically speaking, you know, was able to work and able to care for himself.
This issue, just on failure to take responsibility, I've had that come up at trial a number of times. And it often comes up in this type of context where there's been a liability finding, summary judgment, that sort of thing. But the jury charge, which is going to follow that summation, doesn't say anything about, well, you, ladies and gentlemen, you can award enhanced damages if you find the defendant failed to take responsibility, failed to apologize. I mean, all of these kinds of emotional heartstrings. And so for that reason, it's not uncommon to have an objection at that point and say, and the argument is essentially, you know, Your Honor, the jury's going to think that they can consider this. They can't. And then there's usually a corrective charge. I didn't see that objection here, though.
And Your Honor, again, I think that this is one of those kind of procedural nuances here with the fact that you've got a damages trial with this liability determination still pending and then the decision coming thereafter. Again, our concern is not the fact that there was a reference to the 240 determination, which was accurate at the time. It's that there was this intent to link the two, the damages verdict with the liability determination. And now plaintiff's counsel is saying they're two separate issues, but they're either joined or they're not joined.
But the problem that you had with the summation isn't the fact that there was a liability determination. The problem you had is that it's like a kid threw a baseball at a window. And that was still just as objectionable as it always is.
And Your Honor, I do think that there could have been a stronger objection made at that time. But again, the issue is that when the jury is anchoring their decision, and this is not a situation where I think the verdict is maybe a little off. I think this is very patently and obviously a verdict that was rendered that includes alternative treatments, it includes.
We understand, we understand.
Yes, yeah. So it may be a different situation if it was shaded differently, but it's a very clear situation what the jury did here. Thank you, Your Honors. May it please the court. Ann Wheeler for the plaintiff, Joe Ross. This is an appeal from a 4404 motion to set aside the verdict that the defendants have not submitted a sufficient appellate record for this court to make a reasonably informed determination on their claims. 4404 motions were made. Judge Hanna denied them in their entirety after presiding over an 8-day trial, hearing all of the trial proofs, including opening charges, opening statements that are not in this record, medical testimony.
There's a lot that's not in this record.
There's a lot that's not in this
Kind of
record.
been
Your Honor.
cherry picked what's in this record, and what is not.
That's correct. And it's not just small portions, it's portions that are directly relevant to all of the claims that they are making. So we think this appeal is fatally flawed at the outset. Particularly on the issue of this reference to the liability determination during the damages trial. There's really two things that are going on here, two arguments that the defendants have advanced, one of which is in this brief, one of which is not. So what the defendants are arguing in this brief is that this case of Griffin sort of creates this bright line rule that when you have a liability determination getting overturned by a court, the damages determination necessarily must be overturned.
But Griffin didn't say that. I mean, it said those words, but the underlying facts of Griffin are much different in this case, aren't they?
Yes, Your Honor, incredibly different. So in the Griffin case, we have a unified trial on liability and damages. We have a judge deciding at the close of the plaintiff's proof to grant a directed verdict on the liability issue. The trial proceeds on the damages question. The jury renders a verdict on damages. The post-trial motions are made. The judge sets aside his own liability determination. The judge then sets aside some, but not all, of the damages awards by the jury. So we have a case where the liability determination was wrong, the damages determination was wrong, and that is not what we have in this case. In this case, we have Judge Hanna upholding all of the damages determinations or decisions rendered by this jury. And so under those facts, it makes total sense. When you have a liability determination that's wrong, when you have most of the damages that are wrong, you got to go back and try the whole thing again. And we may concede that if that was the case here, we might have to go try the whole thing again, but that's not what we have here. We otherwise have damages renderings from the jury that are fully sustainable by this record. And the Griffin court, in making that single solitary statement that because liability was overturned, we have to go try the damages, they cite to the case of Soto from the First Department. The Soto case says there was a unified trial, liability and damages. Judgment, appeal was given, judgment was entered. The case was appealed. The liability was overturned. The court noted that the damages number was good, should be entered as a judgment after the liability is retried, but the judgment in that case had to be vacated, which we totally agree with that principle. You can't have a judgment on money damages entered before you have liability determination. So the rule is actually stated in the Soto case. And the Soto case stands for the proposition that you can absolutely have a good damages verdict and have a bad liability verdict, and you only have to go retry the liability. So we would respectfully request that this court follow the Soto case.
What was the big rush here? And, why did you have to try this case at that time? And you knew you had this contentious appeal on liability. And you also had the issue of these examinations on the eve of trial. And all of a sudden, this thing has to be tried right away. And now we're all in this situation, which it wouldn't be.
We respectfully disagree with defendant's characterization of the alleged surprises. It's fully briefed in our papers.
Well, your brief seems to indicate that the course of treatment would have been the same regardless, but you don't dispute that these examinations happened on the eve of trial.
It was continuing medical treatment, Your Honor, which in every case where a plaintiff has permanent injuries, the plaintiffs continue to be examined by their doctors.
But that's what the dispute is. The dispute is they're saying that these are different types of treatment that came up because of the examinations a week before trial. You're saying no, that these were part of a continuing course of treatment.
We're not only saying that, Your Honor, we're saying that these specific treatments were specifically pled, and they were. We did a supplemental bill of particulars more than 30 days before trial. That bill of particulars expressly incorporates by reference a life care plan. The life care plan disclosed more than 30 days before trial expressly lists the neurocord stimulator. It expressly lists a right shoulder arthroscopy. So the idea that the defendants are surprised to learn about this, I think is frankly a mischaracterization of when things were disclosed. The nature of the doctor's testimony as to why they're needed, there was an additional medical record between the trial and the disclosure, but we anticipated and pled the needs for those treatments. And the defendants really have failed to articulate this prejudice that they're alleging.
So I have a question about that. So I know you put on a bunch of experts, and I can't recall this. Did they put on experts as well? Were the experts then able to discuss these medical issues?
They did put on experts, Your Honor. They put on Dr. Mason and Dr. Moreland. Dr. Moreland was able to give unequivocal testimony about his opinion that the neurosurgery was not appropriate for the plaintiff's condition. And similarly, Dr. Mason had, before trial, rendered an opinion that none of the treatment needed by the
So in
plaintiff.
other words, yes, they did put on experts and they had that opportunity.
Correct. And the experts never said that they didn't have enough time to review any of the claims. They never said that they were provided with copies of the bills of particulars, which reference future surgeries in 2021 and 2022. They never said that they got those bills of particulars. Okay, fair enough.
Can I ask one other question about your preservation argument? Started with a little bit on the record was so limited. Okay,
Yeah.
but you have another argument on that too, don't you?
I do, yes, specifically on this issue of prejudice. And if I could say two procedural things, Your Honor, there was a separate motion to set aside the verdict that is not in front of this court after the liability determination was overturned. This concept of prejudice, which is not fully briefed here, which is not really even alluded to until Ms. Hanson's reply brief, it wasn't briefed here. There's a separate motion, there's a separate order that Judge Hanna denied.
Right, that was after all this.
That was after. So there's a totally separate record that needs to be looked at that briefs the prejudice issue specifically. So at the very least, I would submit that this prejudice issue would need to be considered on a separate appeal if it's procedurally appropriate, which is something I don't really know. But the bigger issue is that we don't have the trial record here. We don't have opening statements. We don't have jury charges. We don't have any questions about. So
again, we understand.
Okay. Yeah. So the idea that they were prejudiced, it wasn't preserved during the trial. And the nature of the prejudice articulated in the separate motions was that the plaintiff introduced the concept of liability into the trial to inflame the jury. That is doubtless an objection that existed at the time that the questions were being asked that are not in this record, and the defendant simply didn't object. There was no objection on the basis of prejudice during this trial.
Is there any other reason that counsel would bring that up? You know, except to inflame the jury? Is there any legitimate reason to discuss the liability issue at all during the damages part of the trial?
I think to give the jury context for that their limited role is to assess the damages. You hear things that happen during a trial. All juries come to the courtroom with their, their life experiences, and we simply did it a few times. It wasn't hundreds of times as suggested in the briefing. I estimate it was between 5 and 10, but we don't have this record here in front of us. But the questions during the trial were specifically done for the purpose of reinforcing that role of the jury and being looking at the damages in a limited fashion. There were specific references, if I could just one more thing, Your Honor, in the closing, there were specific references in the closing that Ms. Hanson brought up. What's not part of this record is Ms. Hanson's closing, where counsel stated that Northeast wasn't at the injury site. We're not sure if this accident happened. Okay, the jury heard those comments that are not in this record. We did object. Judge Hanna gave a very limited instruction to the jury that this trial is only about damages. So we shouldn't ignore that. But we felt that we were prejudiced in some respect
by that statement. So we did have some statements in our closing that are not contextualized because we don't have the full record here. And the defendants didn't object as we did. So that went into the record without objection.
Thank you. 475, ACA versus Jenny Dembski, MD. Oh, I didn't realize it. Justice Nowak is recused on this matter. Go ahead.
Good morning. May it please the court, Molly McGorry with Connors LLP on behalf of defendants Jenny Dembski, MD, and Kaleida Health DBA Women and Children's Hospital of Buffalo. As the court knows, a summary judgment motion is essentially a trial on the merits, except we, the defendants, have the initial burden. And here, the defendants established that they attempted to avoid shoulder dystocia from occurring in this patient by repeatedly counseling the patient on the risk and offering her a C-section. When she elected to decline that, and shoulder dystocia did in fact occur as feared during an already precipitous delivery, the physicians appropriately managed an emergent circumstance by performing proper, timely maneuvers to deliver the baby without hypoxic brain damage or death. The defendants did everything right. They met their burden and more. The plaintiff in opposition failed to meet their burden in any number of ways that are independently dispositive. The plaintiff did not and cannot point to an act of negligence that can be supported by admissible evidence in this record. Instead, plaintiff improperly relies solely on a purported injury to demonstrate negligence. But plaintiff has not even proven that that injury exists, and in fact, submitted evidence that demonstrates it does not. And now, on appeal, plaintiff has misstated facts, misstated the deposition testimony, and raises entirely new arguments for the first time. Plaintiff essentially acknowledges that she has not and cannot meet her burden on negligence. She asked the court to allow her not to prove her case. Without citing applicable precedent, the plaintiff claims that the doctrine of res ipsa loquitur applies to impose strict liability on a delivering obstetrician in all shoulder dystocia cases that involve a permanent brachial plexus injury. In other words, regardless of the facts and circumstances of this delivery, if there is a permanent brachial plexus injury, the delivering physician must be liable. End of story.
We have a counselor. Aren't you making the opposite? Aren't you arguing that because she opted not to follow the advice on a cesarean, that relieves the doctor of liability because there was the inherent risk of the vaginal delivery here?
Judge, what I'm saying is that shoulder dystocia and resulting brachial plexus injuries, which are known to occur, it's established in case after case that shoulder dystocia and a brachial plexus injury is a known complication of a shoulder dystocia. Our doctors counseled her that that is a risk, that they can't guarantee that it is not going to happen, and that they think that because of that risk to her, that she would be better served by a C-section. They recommended that to her. She elected to decline, and that was her right to do that. But when the shoulder dystocia does occur, exactly what they feared happened. This fetus, the baby already was bradycardic, and the physicians were placed in a position that they did not want to be in, that they sought to avoid, and they handled it as best they could.
But didn't they bring up the issue that it was excessive, the force was excessive and moving this baby around, et cetera, and that's what caused it. So isn't that an issue of fact?
No,
There's testimony to that.
There is not testimony to that. There is testimony that the providers used gentle traction to deliver. Traction has to be used in every delivery. It's how babies are born. And the expert never says that traction should not be used. The expert says that there must have been excessive traction. And the only reason I know that is because there is a permanent brachial plexus injury. But here, we don't even have evidence of that permanent brachial plexus injury. So assuming that res ipsa could be applied, which the case law demonstrates that it cannot be. There are numerous cases that hold specifically in shoulder dystocia cases. This is not a case of res ipsa. assuming, Your Honors, that somehow the plaintiff could argue that. The plaintiff doesn't have admissible evidence of a permanent brachial plexus injury.
Was that decided at summary judgment? There's no injury? I mean, isn't that something that would be proved at trial, that what the damages are?
Well, the plaintiff has to, so it goes to, it's really a question of negligence, Your Honor, because if there is no permanent, and it needs to be a permanent brachial plexus injury, according to their experts, it has to be an avulsion, this avulsion at C6-7 that the experts.
And you're saying that's not there? Or no proof, there's no proof in the record of that?
I'm saying there's no proof in the record because all that the expert relied on was an uncertified MRI report. So the report is not admissible evidence. The expert relies on that report and purportedly relies on excerpts from the record from Children's Hospital of Pittsburgh. It's a 3-page operative note. That operative note contradicts the radiology finding. The operative note says that there are no avulsions seen. So on direct visualization, less than a month after the MRI, the surgeon goes in and says, there are no avulsions here. And that is what their experts say is the permanent brachial plexus injury. So without evidence of that injury, and they have never explained that, they've never explained this, which was also an exhibit that they submitted for the Children's Hospital records, also uncertified. So not only did their expert rely on uncertified excerpts of records, but those records in and of themselves are contradictory. And the surgeon looks at the nerves themselves, and there's a finding directly in her operative report that there are no avulsions seen.
Okay,
So
we're gonna look it up.
So the plaintiffs have not even established that the injury exists upon which their whole claim is based.
I think you've made that point. Do you have anything further?
Just to revisit the notion that this is a res ipsa local.
No, you don't have to revisit that.
And Judge, I would also note that there are unaddressed theories in the plaintiff's experts report. So, I think based on the court's recent Van Hook decision, the only allegation in this case that the plaintiffs attempt to argue is that there was improper excessive force applied, of which there's no evidence in the record. So any other allegation, including, they allege in the bill of particulars failure to perform a C-section, even though she was asked to perform a C-section.
We should probably know all of the facts or all of the discussion about that C-section. What was told to her, what she understood, and isn't there questions of fact loaded into that discussion alone?
I don't think so, Judge, because it's memorialized in the contemporaneous medical record. So I think in my reply brief, Your Honor, I directly quoted the notes from the chart. So when the plaintiff comes in, first, she had been counseled prenatally. There was a discussion.
Again, you don't have to go through each and every one of those because we have all that in front of us.
There are two notes documenting the discussion with Ms. McMillan. There is an independent recollection of one of the resident physicians about sign out and about how this case was used for the residents as a teaching example of how you appropriately counsel on the risks of shoulder dystocia. So all of those are in my reply brief on pages 14, 15, and 16, if you'd like to take a look at the exact contemporaneous medical record.
Thank you.
Thank you.
Good morning. May it please the court, Kate Dempsey for Ms. Allen and DT. I'd like to just pick up where Ms. McGorry left off and the judges were asking questions. This very complicated case is actually very simple. And the reason I say that is that questions of fact are all over this record. They're all over the record from just the actual contemporaneous records, in that all of the defendants, when I asked them during the deposition, said that a cesarean section was not contraindicated and it was not against medical advice. Okay, so you have that there. Then you have the plaintiff herself, Ms. Allen, saying nobody counseled me on not getting a cesarean section. In fact, I signed a consent for a cesarean section. And when I asked Dr. Dembski, the named attending OBGYN, whether whether the trial of labor for a woman who already had 3 large babies and successful vaginal deliveries, was that against medical advice? Were you acceptable to attempting a vaginal delivery? She said yes. And so right from the, yes, Your Honor.
Are the questions of fact resolved, as Ms. McGorry said, by those notes that the doctors wrote in the medical records?
No, Your Honor, because they're not. The testimony is all over the place. The records are all over the place. And similar to all the records nowadays, conversations are carried over. So I asked specifically every resident, every doctor, do you remember having this discussion? No.
No, none of them remembered.
Right, exactly, Your Honor.
What about your opponent saying that there was no evidence of the injuries to DT?
Okay.
Could you comment on that?
Yes, Your Honor. Well, what's interesting in this case, and different than most brachial plexus motions for summary judgment, is that the defendant, the moving party, only used an expert affidavit, only using the birth records, right? They didn't even mention any of the injuries at all to the baby, and said, we weren't negligent. And even though I didn't mention any of the child's injuries, we didn't cause any of them. So seeing that, Your Honor, we moved against including the expert affirmations of both an OBGYN and a neurologist, pediatric neurologist, who then looked at the records of both the defendant hospital, the subsequent treating records from defendant hospital, because the infant treated there for years and years and years, and also the surgery records from UPMC, which is out of state, and also the MRI and Dr. Zerny's records. Now, it is true that they are not certified records from University of Pittsburgh. But as I mentioned in my brief, the Cook case, that is not in and of itself, doesn't say that the proof is not admissible or preclude our ability to combat the summary judgment motion. Instead, the affirmations rely on both certified records, the deposition testimony, as well as the records that they read. And so there is admissible proof, and those records are before the court as part of my affirmation in opposition. They just were not included, interestingly, by the moving party in their attempt to argue summary judgment.
Yeah, thank you.
And those are all the questions I have, unless Your Honors have any further questions.
Thank you.
Thank you.
476 in the matter of Gary Lucky. I think that's how you pronounce it, Lucky. Did I pronounce that correctly? Did I pronounce it correctly? Thank you. I haven't been doing a good job of it, so I just checked.
Good morning, Your Honors. My name is Teresa Bennett, Barclay Damon, and I represent Gary Leckie in his capacity as trustee of 2 trusts that are the subject of the 2 proceedings before the court today. You know, some of these issues are legal issues that Your Honors have dealt with multiple times, so please feel free to interrupt me and tell me to move on. The first trust is the Edmund and Helen Leckie Irrevocable Trust.
So that's the 2004 trust.
The 2004 trust, correct. There's really 3 issues in that matter. The first is Mr. Leckie is contesting the dismissal of the statute of limitations and Lachey's defenses. Surrogates court initially did that sua sponte without any indication from Mrs. Vicus that she was surprised or prejudiced in any way by the late pleading of that claim. The evidence indicates that she was well aware that that was going to be the defense that Mr. Leckie relied upon based upon her failure to raise that issue in her response to the motion, and also her answers to questions at the deposition.
Pleaded though.
I'm sorry?
Did she put it in her pleadings?
Did he?
Yeah, I'm sorry.
He did not put it in his pleadings. Okay. He did not plead it, correct. Surrogates court also determined on the merits that the statute of limitations and Lachey's defenses were meritless. Surrogates court correctly determined that Mrs. Micus's petition was not filed until October 18, 2019. which Mrs. Mikas disagrees with, but she has not appealed. But the court then applied the discovery rule, which is improper to this contract proceeding. And then also misapplied the discovery rule, even if it did apply. First, the surrogates court said that the statute of limitations began to run when she learned of her removal as a beneficiary, and that it ends 6 years thereafter, where the discovery rule actually provides that learning gives you a 2-year period of time, and in which case the discovery rule does not save Mrs. Mikas from her failure to timely plead. With respect to the laches defense, we do agree that constructive notice is required, but we would submit that Mrs. Mikas received multiple letters concerning her removal in 2012 and 2013. She claims that even though the letters were properly addressed to her, that she did not receive them. And in her response brief, she suggests that those letters were never sent by Edmund Lecky's counsel. But she admits knowledge of the contents of those letters. She says, "I know that my father wanted me to resign as a trustee, but I didn't know how to do it." And she even says that she discussed that with Edmund Lecky before he died. So it's not as if she did not know. She just intentionally determined that she would not do anything about it. I think she even says in her deposition that she decided not to confront Edmund Lecky about it because he would have denied that he did it or would not have understood it. So that is not the suggestion of somebody who does not know. It is somebody making an intentional decision not to address their rights in a timely fashion. And as a result, Helen Lecky died. And 3 years later, Edmund Lecky died. And now we have 2 missing witnesses, and we cannot determine whether there was capacity or not. For the first time in her response brief, Mrs. Mikas argues for the application of an open repudiation rule to commence the running of the statute of limitations. I will note that she fails to pinpoint when appellant openly repudiated his fiduciary duties. And the case law that she cites is an opposite because it applies where the fiduciary relationship is not terminated, where the fiduciary has done something, but the fiduciary relationship continues. And that's not the case here. Mr. Lecky didn't do anything to repudiate his fiduciary duties. Edmund Lecky terminated the fiduciary relationship, and so those cases have no applicability here.
Can you address the capacity of the mother?
Yes.
Please.
So the issues that we have with the surrogates court's decision about the capacity issue is first that the court applied a presumption of capacity. And in this case, the presumption of capacity doesn't apply because the presumption of capacity applies to somebody that's executing a will or a document. In this case, Helen Lecky didn't execute anything. She was incapacitated, and therefore Edmund Lecky, pursuant to his rights under the trust agreement, executed a document which he was allowed to do, removing Mrs. Mikas as a beneficiary.
To do if she was
incapacitated.
Right. So that's still a big question.
Right. And I think the opposition here is that there is insufficient evidence that Helen Lecky lacked capacity because the treating physician's affirmation standing alone was insufficient, but that's not what we have here. We have a treating physician who has attested to her incapacity, has written a letter stating that she is in.
So we have that, but we also have other testimony indicating that it's a question of fact. I think if there's other testimony that indicates that maybe she did have capacity.
I don't think so, Your Honor, and here's why. I think the only evidence that we have and the only testimony that we have and the only testimony that the court relied upon was the testimony of an interested witness. And we also have a transcript that interested witness testified to a single conversation that she had with Helen Leckie after the power of appointment was executed.
We give that interested witness charge 1,000 times in our careers, and it says to the jury, okay, this isn't a jury, an interested witness is not presumed to be lying to you. You know, you can decide whether you accept their testimony or not. So all of the idea of the credibility, the chance that this interested witness had to see and hear and observe what he was testifying about, aren't they all important facts? I mean, you know, that we need more than the piece of paper.
The law, Your Honor, says that you may use evidence that is inadmissible pursuant to the dead man statute, but it cannot be the only evidence. And here it is the only evidence. And what we have in the response brief is reciting what this daughter's testimony will be, inadmissible. And then we have this reference to these other affidavits, which we don't even say who those affidavits are from. They're from Mrs. Mikas and her son. And so really all that we have here is testimony that is inadmissible under the dead man statute.
We'll look at that and see whether or not there's a question of that.
There was an issue that was heavily debated in front of the surrogates court, and that was the issue of what level of capacity was required in order to execute or to render her incompetent and allow Edmund Leckie to execute the power of appointment. The surrogates court determined that it was testamentary capacity. We submitted that it was contractual capacity. Unless your honors have any questions about that argument, I'm happy to move on. And the last thing with respect to the 2004 trust is the standing issue. We submitted to the surrogates court that Mrs. Mikas lacks standing because she has yet to seek to invalidate the power of appointment, and thus she is neither a beneficiary nor a fiduciary of the 2004 trust. And what surrogates court says is she's pleaded enough facts in this accounting proceeding seeking to compel an accounting to possibly invalidate this power of appointment, and thus she has standing. And I submit to the court that kind of turns standing on its head. First, you must have it, and then you can proceed. In this case, we don't have it, but we're proceeding anyway. Unless your honors have any other questions about the 2004 trust, I'd like to turn it into
time. So
okay.
Get to the 2012.
With respect to the 2012 trust, the largest issue was whether the appellant was entitled to the protections of the 2 exculpatory clauses. Surrogates court determined that he was not permitted, and that was because the court determined that he was not accountable to anybody, but in reality, and in pursuant to the very cases that surrogates court cited, he was accountable to the settlor, which is all that is required to render those provisions, particularly in cases of inter vivos trusts where there is a lesser scrutiny on those types of general exculpatory clauses. That was sufficient accountability to render that provision effective. The second provision is a provision that permitted Gary Leckie to rely upon the advice of counsel. And surrogates court made a number of determinations about why he was not entitled to rely upon the counsel that he selected. And I would submit that those rationales basically wrote this second provision allowing him to rely upon the advice of counsel right out of the trust agreement. First, surrogates court found that the beneficiary's consent to the advice received was required. There's no such requirement. Indeed, were there consent, there would be no need to rely on that provision because there would have been a waiver by the beneficiaries. Surrogates court found that whether the beneficiaries were damaged by the advice was a relevant consideration. And again, if there were no damage, there's no need to rely on this provision. Surrogates court held that appellant could have violated the provisions of a different trust agreement, the 2004 trust agreement. And that determination is perplexing because Surrogates court had already dismissed the self-dealing claim based upon the exact same facts and circumstances. Surrogates court determined that appellant could only rely upon the advice of counsel if he picked the right attorney, claiming that there was a conflict of interest. Gary Leckie went to the very attorney that drafted the trust agreement to tell him how to fix the situation. We have a look back period of 5 years. Edmund Leckie is 2 years into this look back period, and we've got to fix it so that we can save this trust.
I understand.
I asked you about the Prudent Investor Act. It may be where you're going next, but if not, if you could jump ahead to it. Sure. I understand from your brief the dynamic that we have between serving the interests of Edmund versus serving the interests of the remainder beneficiaries. The question I have is that, and I know that the court found in favor, in summary judgment, in favor of the objectants, why isn't there an issue of fact as to whether keeping the funds where they were was prudent or not? Why isn't there an issue of fact that, as opposed to your argument, I think, is that your client's entitled to summary judgment?
We argued in favor of summary judgment, but we do agree that at minimum, there are issues of fact as to how much and whether he was required to invest all of those funds. Our position is that he was not. In fact, the Prudent Investor Act does not require him to diversify unless it's in the interest of all beneficiaries. It was not. But I agree with Your Honor that at a minimum, there is an issue of fact as to whether and how much of these funds should have been invested.
Well, the prudent investor rule doesn't require him to chase returns, and that seems to be what the surrogate was saying.
Correct.
And at the time of this, inflation was like 0. So even 1% was a higher return. I don't understand why you're conceding that point, though. You know, it's better than where you are right now. But why would you even? Because that exposes trustees to all kinds of liability. Every case could be a question of fact for if the trustee decides to stay in FDIC savings account to preserve capital, eating interests. But you're saying you're fine with a trial on that to let the judge decide that.
I am certainly not saying that. Our position is that summary judgment should have been granted in favor of the trustee. But at a minimum, there is an issue of fact. If it is the case that he was required in some way to diversify those assets that were given to him in a Berkshire bank account.
It's either out and out summary judgment for you or else there's an issue of fact. Do you have anything further?
I do not.
Okay.
Good morning, Your Honors. My name is Cecilia Cannon with Bousquet Holstein, representing Susan Mikas, who was the petitioner in the 2004 trust proceeding.
We're aware of
Okay,
everybody
all right.
is.
So to try to go directly to some of the points that were raised and the places where you were focusing. But actually, I want to start with standing, which is not where counsel had started. The issue of standing is something that is typically addressed. Do you have standing to bring the proceeding that you have brought? And we cited in our brief a case that says it's totally appropriate for the court to say, let's proceed on discovery, determine if you have this standing, and if you do, then we'll let the rest of the thing go forward. That's what happened here. And it did not happen over objection. Prior counsel, not the present firm, but the prior counsel that was representing Mr. Leckie at the time that the petition was initiated, agreed, yes, it makes sense. Let's proceed on discovery with respect to Helen's capacity and the validity of the exercise of the power of appointment. So to go back now at the end of the case, when you've got new counsel and try and unwind the way that the court and the counsel in open court on the citation return date agreed to proceed with this, is just, it doesn't make sense. It's a waste of judicial resources to do that. With respect to the technicality of whether or not there was a request to invalidate the power of appointment, the exercise of the power of appointment, I will note that the petition requested such other further and different relief as was necessary. And the issue of the validity of the power of appointment was very clearly put forward both in the petition and in the response to it, because it was addressed in affirmative defenses, not just by the denial, but by affirmative defenses. So it was clearly placed at issue. There was a request for a leave. On the statute of limitations issue, I want to jump to the point about the October 18th filing and it's not appealed, right? So I would disagree with that characterization of what the procedural posture here is. The question that the trial court decided was, does the statute of limitations bar this claim? And the trial court then decided, no, the statute of limitations does not bar this claim. Appellate courts all the time find that the trial court reached the correct disposition for reasons other than what the appellate court believes is correct, and they affirm on other grounds. And that's what we're asking for here. The October 18th filing, there's no dispute that the documents were submitted to NYSEF October 9th, and that this was 1 week before the earliest possible date anybody has argued for the statute of limitations, right? The only thing that happened after October 16th, 2019 was the payment of the filing fee to purchase the index. And that's set forth in the brief to keep in mind, it's not today when you go in and you do the credit card. I would submit that it was not necessary. In fact, I'm not even sure I could have appealed it. I don't think I could have because I was not an aggrieved party. The court found in my favor on the statute of limitations issue. This court, if you don't agree with all of our other arguments, which I'm not rehashing, but am by no means waiving, but that were set forth in the brief, the court could affirm on other grounds on this basis. With respect to the question of, and I would just note on that point, the fact that it wasn't pled and that prior counsel didn't move to dismiss at the outset, I think that that is significant in terms of what prior counsel for Gary Lucky thought, which is essentially had the same analysis the surrogates court on the statute of limitations. Why waste time and money on all this discovery? So on the capacity issue, again, keeping in mind the procedural posture, this is a motion for summary judgment only by one side. In the 2004 trust, we don't have dueling summary judgment motions, just one. And all the court said was material issue of fact on capacity that we have to have a trial on, right? So it hasn't made any ruling as to capacity or no capacity. It's just said there's enough here that we have to have a trial. That's very consistent with how capacity is typically viewed, which is to say, this is usually something that requires a trial. And also, they never really.
It is interesting that the question of what's the capacity. I agree with that, but right now we're just at a stage where we have to deal with the issues of that, correct?
I'm not sure I understand your question.
As you brought up, as opposing counsel brought up the what the capacity. Is it for a contract? Is it for the, it's an interesting question.
It is an interesting question, and I think the surrogate court had appropriate analysis here in terms of saying, look, when you look at the exercise of the power of appointment, that is more akin to a testamentary provision. I'm not clear that it was dispositive. There's nothing in the court's decision that suggests if he had applied contractual versus testamentary.
That's exactly what I'm saying. I'm just saying it's an interesting question, but it doesn't really.
It is, and it was certainly. As you can see by the fact that it was discussed at oral argument in the trial court below, it was certainly something that was focused on, perhaps for that reason. On the point of the dead man statute, again, the point was made that Valerie and Eric Micas are not interested parties in the 2004 trust proceeding. The dead man statute is the interested party notion is interpreted very strictly. Only their mother would be the beneficiary. There's no a possibility of, oh, they might get this at some later point if she gets some of it. That's not the way the dead man statute analysis works under case law. And I would also point out that even if it was to be deemed to apply to what they say here, Gary Leckie put at issue Helen's capacity and opened the door to it. So when that's done, when the door has been opened, then you're not allowed to do that. And the statute is by no means clear reading, but if you read down through it, that's an exception that it says, unless they've put something forward about this. So with respect to laches, I would say they focus on prejudice. They don't focus on whether any supposed delay was reasonable or unreasonable. They've really given no reason to why this is an unreasonable delay. They also continually discount the statement that she did not receive notice until after her father's death, right? There's certainly a lot of testimony that each side has pointed to on this point, right, to say one way or another. But I also think that what you're seeing is removal as trustee versus removal as beneficiary getting squished together, as well as a question of what did she know now, or what did she know as of the date of deposition versus what she knew at the time. And if you look at the letters that they repeatedly harp on, right? First of all, the 2012 letters were before the exercise of power of appointment was signed. They're irrelevant. Even if she had done due inquiry, then what she would have found was he hasn't signed anything, right? So we're really only talking about the October 17th, 2013 letter, right? It says he will do this in the future, right? Which is a really interesting statement considering he supposedly signed it the day before. There's no sworn testimony that that letter was actually sent. They did not put a single thing in from the attorney whose files that letter came from that said this was actually sent. What we have is her saying, I never received it.
We understand that.
So on the question of the 2015 discussions, again, those letters from the Office of the Aging do not, none of them talk about removal as beneficiary. They talk about her access to the house. That's really what's being talked about there. And finally, just at the end, to move to the question about the prudent investor rule and the general questions from the bench about why why do we not rule in summary judgment this way? Or, why isn't this a question of fact? What is different here is that the income beneficiary, the stated interest of the income beneficiary, Edmund Leckie, is to minimize income. That's a really different scenario. Normally, when a trustee is trying to balance the income beneficiary's interest versus the remainder's interests, they're saying, well, the income beneficiary wants more income, so I need to invest a certain way to do this. The remainder men want growth, so I need to do a different thing. How do I balance between those two things? Here, their interests are aligned by the statement of the trustee who said, we did not want Edmund to have income. It was just going to go to the nursing home. So why generate more income? Well, that says that a growth strategy for the remainder beneficiary was the appropriate strategy. And it's very clear that he made no attempt to do that. In terms of the preservation of capital, and wasn't it appropriate to preserve capital, which I think Judge Greenwood, you had suggested. What I would say is there was no right here for him to withdraw principal, right? Only for income, and it was said he didn't want income. So essentially you're saying Edmund Leckie doesn't want anything from this trust, even though they did take money out from the trust. And there's no debate that the withdrawals for Edmund's nursing home were in violation of the trust terms. So to the extent that they want to say rely on advice of counsel and the general exculpatory provision with respect to this, first, it's not accurate what they say, where they say there was no real basis in their reply brief at 23. There's no real basis for the decision on the advice of counsel. To the contrary, the circuit court collected cases about when are you entitled to rely on advice of counsel. It identified 4 key factors that based on its review of the cases it saw, and they don't really address that. So it's not accurate to say there's no basis for it, right?
Can I ask you one question? Did the trust documents themselves say that, that they were looking for income and not preservation of capital? That they didn't want to pay the nursing home money? That wasn't in any document. That's just like a private understanding.
That was the statement of the trustee, I believe, in his affidavits, where he was saying that this is why we did it this way.
Right, he's explaining it after the fact, but that's not the document that directs him how to act as the trustee.
Well, the document that directs him how to act as a trustee just says, Edmund Leckie and Helen Leckie can get income during life, and then it goes to their grandchildren, after death, right? That's all the document says. So just as is typical, the trustee has to look at whatever is appropriate to determine how do you balance these things. And that's why it's relevant what Mr. Leckie said, because those were the facts as it applies to this particular trust. And that's the reason for the decision as a matter of law.
Do you have anything further?
Not unless your honors have questions about the exculpatory clauses any further.
Thank you.
Thank you, Your Honors.
Court is in recess.